Good morning, everybody. Thank you very much for joining this CMA webinar on our approach to consumer protection. My name's Emma Cochrane. I head up the CMA's Consumer Enforcement Directorate here at the CMA. And I'm joined today by my colleagues, Hayley Fletcher, who's our Interim Senior Director of Consumer Protection, and Sophie Simons, who is a Legal Director who has led the policy team, who have been working on the various guidance documents that hopefully you will have seen over the last month. The purpose of today's session is to talk you through the Digital Markets Competition and Consumer Act's provisions on consumer protection, which came into force on the 6th of April this year. The key provisions in the Act are that the CMA will now be able to directly enforce consumer law. That means we'll be able to investigate, as we already could, but we will be able to make findings that a business has infringed consumer protection law. We will be able to impose directions so that they have to correct that conduct, and we'll also be able to apply sanctions directly to businesses and order redress paid to consumers. So today we will be talking through those changes that the Act brings in. We'll be talking a little bit about our ambition for what the new regime achieves and how it sits with government's broader agenda. We will talk about what businesses can expect when we're acting under our new powers, and we will also talk about two of the key areas where the law has changed, in particular fake reviews and price transparency, audit pricing. We are starting a bit late, so there will be time for questions, and we will make sure that there is time at the end for you to ask questions. If you want to, they are you can post them in the Q&A bar, which should appear at the side of your screen. They will be moderated, and although we'll do our very best to answer as many questions as we can, what we can't do in the context of today's webinar is to provide legal advice about the practices of particular businesses or how the rules will apply in particular sectors. We will, however, look very carefully at all of the questions we receive, even if we don't manage to answer them in today's webinar, so that we can understand where people have questions, where people are not sure what they need to do, and any other feedback that you want to give through the Q&A bar today. Starting with our ambition and really what we're trying to achieve through our consumer protection powers. Many of you will have seen the approach document that we published just before the regime came into force, and this sets out in some detail how we will go about exercising our powers under the new regime. But really, I think there's two key things that we think about when thinking about what we're trying to achieve with consumer protection, and those are reflected in the strategic steer from government, which has referred to the CMA's focus on free and fair competition and effective consumer protection, which both support growth. And there's two ways that we think that this happens. Firstly, by effectively protecting consumers, we ensure that those consumers are confident, that they are happy to spend their money in the economy, which drives businesses and which drives growth. And also, effective consumer protection ensures a level playing field. So unpacking both of those a little bit more. When consumers feel protected, they feel able to go out and spend their money in the economy, knowing that the information they receive about the price of a product or the different features of a product or service that a business is selling them are accurate, that they're not misleading them, that they're not omitting information that consumers need to make decisions about how they spend their money. Consumers need to know that where they're relying on reviews online, for example, that those reviews are real, that they're not generated by AI, and that they're not being paid for, that people, perhaps social media influencers online, are not being paid to advertise a product, but not telling people that that's the case. And once a customer has decided to spend their money, they also need to know that if things don't work out the way they hoped or expected, that they are protected, that they're able to exercise their statutory rights. So, for example, if they buy online some clothes and they don't look like they thought they would, or they don't fit like they thought they would, that they're able to return those clothes. And if those clothes then fall apart just a couple of weeks later and they weren't fit for purpose, that again, they're able to return those clothes and get their money back. This is what makes consumers confident and happy to spend their money in the economy. What we've also heard is that businesses who invest in their customers, who value their customers, and there are many, many of them in the UK, want to know that they're competing on a level playing field. So if they spend money ensuring that they comply with the law and do the right thing by their consumers, by their customers, they want to know that their rivals are playing by the same rules, and they're not going to lure customers away with a headline price that doesn't really exist, or by advertising features of a product that aren't any different to what the law tells them they need to provide. And when businesses are confident that everybody's playing by the same rules, they are more happy to invest in doing the right thing by their consumers. And we see this really as a virtuous circle, that businesses are incentivized to invest, and consumers are confident in shopping around in the economy and spending their money. And together, that really works together to drive growth. And that's what we as the CMA are focused on. So what does this mean in the first 12 months? Well, really, it means we're going to be focusing our resources and our efforts in two areas. First of all, we want to help businesses understand what it is that they need to do to comply with the law. We've had the opportunity to speak to a lot of businesses over the last weeks and months, and we have heard that they are keen to do the right thing. They want to do the right thing, and there's some areas where they need a bit more help to understand exactly what it is. And it's our job to provide that guidance, to provide that help. And so in the first 12 months of the regime, we're going to be focused on supporting compliance. And we're keen to get out there and talk to businesses about those areas where they do need more guidance and where we can help to provide that. That's not to say that we won't be using our enforcement tools, and we have a number of enforcement tools at our disposal. Those include advisory letters and warning letters and direct enforcement powers, which are what is new under the new regime. And we've indicated it in our approach document that over the first 12 months, we'll focus on the more egregious practices where the law is clear. And that will include, for example, aggressive sales practices that prey on consumers, particularly those in vulnerable positions. It will include providing information to consumers that is objectively false, that is simply not true. We'll be looking carefully at the banned practices. These are the list of 32 practices which the law tells us are always unfair. And in particular, we'll be looking at the new banned practice, which relates to fake reviews and which Sophie will talk more about shortly. We'll be looking at fees that are hidden until late in the purchase process. That harms both consumers who are misled by a headline price that doesn't really exist, and it also harms fair dealing businesses who can't compete on a false headline price that doesn't include all of the charges that consumers will encounter. And lastly, we'll be looking at unfair contract terms, so those in particular that are very clearly unbalanced and unfair, and those that impose exit charges on consumers who want to get out of contracts. So those are the areas that we have indicated we'll be focusing on in the first 12 months. And I now want to hand over to Sophie, who will talk a little bit more about what the DMCC Act changes.
Thank you, Emma. So just looking at the DMCC Act, it's actually set in, there are 6 parts, but there are sort of 4 main ones. So part 1, the digital markets, part 2, competition, and the ones that we're focusing on today, which are parts 3 and 4. So part 3 is about the enforcement of consumer protection law, and part 4 is around consumer rights and disputes, so what we'd probably refer to as the substantive legal provisions that protect consumers. So just thinking about those two parts, they can contain a combination of new and updated law. In relation to both parts 3 and chapter 1 of part 4, they came into force, as Emma was saying, on the 6th of April this year, and they broadly apply prospectively, which means that they'll be applying in relation to actions that have occurred since the 6th of April. So turning to each of those in a little bit more detail. So as I said, part 3 is around the enforcement of consumer protection, and there are two ways we can do that. But as Emma was explaining, the main change for us is really around having new direct enforcement powers, which allow us to essentially find an infringement ourselves. And we also have the ability to impose penalties up to the higher of £300,000 or 10% of turnover, and directions on companies where we find that there is an infringement. Parties' rights of defence have been protected both through the Act and the rules that the CMA has made. We would need to give notice to parties before we impose any penalties. They would have the right to make representations to us. And at the end, parties also have the opportunity to appeal any penalty or directions to the courts. So just to name but a few of those rights of defence as available. Turning to the court-based regime, so this replaces Part 8 of the Enterprise Act 2002. And I thought it might be helpful to just draw out a couple of differences between, because there are many similarities actually in terms of the powers of the courts and the new powers that the CMA will have. But a couple of the differences is that the legislation that the CMA can enforce against is narrower than that the courts have powers over. So the full list of legislation that the CMA is able to enforce against is set out in Schedule 16 of the Act. And also the CMA does not have the power to make equivalent interim enforcement orders that the court does. I would add that for anybody who's familiar with our Competition Act enforcement, the processes that we will be following for the consumer enforcement are very similar as well. So turning now to part 4, actually there were 4 distinct sets of substantive provisions. So there was what we were talking about with the unfair commercial practices, which include provisions on price transparency and fake reviews, which I'll come on to discuss in more detail later on in the presentation. I mean, these replace and update the Consumer Protection from Unfair Trading Regulations 2008. And then there were 3 other substantive provisions. So duties and rights in relation to subscription contracts, consumer savings schemes, and alternative dispute resolution services. Those last 3 will come into force at a later date, and so we won't be discussing them in further detail during this webinar. So that was a brief overview of the elements of the DMCC Act. I was just going to use this opportunity to draw your attention to some of the guidance that we've published, which covers these elements. So we've put out what we call our procedural guidance, which very much explains how the CMA would engage with businesses. That's labelled CMA 200, and that covers our direct enforcement process. We've also put out, as Emma was saying, substantive guidance on unfair commercial practices, and a separate one on fake reviews. So they're labelled CMA 207 and 208. And finally, we've also put out a document which describes more of the landscape. So this is a revised version of what is CMA 58. So that explains how we engage with domestic and international other authorities, as well as providing views on the consumer landscape, which I know Hayley will be talking about in a little bit more detail later on. So that's just a sort of brief overview of what we published in advance of the new regime that might be of assistance to people. So I'm now going to hand over to Hayley, who's going to talk you through our 4 Ps.
Thank you, Sophie, and good morning, everyone. Wanted to talk to you a little bit about this. You would have heard it, I hope, in our sort of external communications. Our 4 Ps, so pace, predictability, proportionality, and process. And these aren't sort of simply nice sort of alliterative words that look nice on a page. These are sort of fundamental concrete actions and differences in what you will see in the way that the CMA operates. And I want to unpack for you kind of very precisely what that's going to mean for how consumer protection is going to look and feel for you. But our primary aim with, as Emma rightly said at the beginning, with everything, is to make sure that we have an effective consumer protection regime in the UK. It's fundamental and conducive to growth. And we are very mindful that we play a very important part in creating the right regulatory landscape for that to flourish. So starting with pace, I think particularly when we're thinking about dealing with possible harms to consumers, it is imperative upon us to act quickly. Now, that does not in any way cut across our absolute commitment to robust processes, and you'll see in our guidance really rigorous, I think, rights of defence, new processes to make sure that we absolutely hear everything from parties during the process. But we really do have a legal duty on us actually to act as quickly as possible, and that's good. That's good for us, it's good for the taxpayer, it's good for consumers, but it's also good for businesses, so that investigations move as quickly as possible and you have the certainty to know what the CMA thinks. So how are we going to make that work in practice? Things that you will see that are new and different from us. If you're subject to an investigation, we will tell you very clearly at the outset what the timetable for that investigation is. You'll know what to expect from us and when, so that you can be really clear about how that's going to operate. We rely quite heavily on robust information, always sort of very rigorous focus on the facts, and that means that we need to ask businesses sometimes some quite detailed questions about what has happened, how, and really understand how your business works and how practice came into market. But we're really mindful that it is work for a business to produce. So we are fundamentally committed to only asking for the information that we strictly need to process the investigation, and we will work very hard to make sure that those requests are streamlined and work with you to do that, to minimise the burden as much as possible. But to be clear, we will still be asking businesses for detailed information that's fundamental to our investigations. You will also see in investigations that real focus on making sure that we are targeted on the issues that are likely to have the greatest impact, whether that be on consumers or any distortion to the level playing field. So if we identify lines of inquiry relatively early on in the investigation that we think that we can stand down, and that can expedite the process and make sure that we're really focused on having the greatest impact, we will follow through and do that. You will see that. So that's a very sort of concrete change to make sure that we work as quickly as we possibly can. But this is a two-way street. We can work at pace, and we will work at pace. But to make sure that cases do go as quickly as possible and we have that certainty, we will rely on businesses engaging with us very constructively, responding to information requests on time, and being open with us when you see that there are opportunities to resolve issues at an early stage. We want you to be open with us as possible, and know that you have an environment with us that we want to genuinely engage with you on that to resolve matters very quickly. Moving on to predictability, which we know can be quite difficult in consumer protection law, and in fact any piece of law where there is sort of underpinned by principles based legislation. And as Emma said at the outset, we are really focused here on providing businesses with as much guidance as possible, but it's got to be the right guidance, and we're really thinking there about how we can provide guidance that is useful for the very smallest business right the way through to the largest, and thinking about how we can make the guidance practical so that it's really very clear for businesses the steps that they need to take to make sure that they comply. And that is an area that you will see us working increasingly on in the next 12 months. We really genuinely want to help businesses get it right, and we know that, you know, from the businesses that we engage with, you also want to get it right, and we want to work with you on that. We want to, so building on that sort of constructive engagement, sessions like today, but we like to get out and about as much as we possibly can, attending events, talking to you bilaterally, having those discussions so that we really make sure that we hear your perspective. And I'm going to ask you to be honest with us and to not sort of spare our blushes if there is a particular line that we are taking or a particular piece of guidance that you think could have been more helpful. To be clear, we may not agree with you, but I would like to hear from you directly if you think there's more that we can do to support you. And I rely on you all to be open and honest with us about that. And we will do in return as much as we possibly can to increase the predictability both of our work, but also what the underpinning law means. And I think we collectively need to recognise that we are at the beginning of a new regime here. Over time, once we have cases and we start to build that precedent, predictability will increase over time. And I think that is one of the really significant benefits that businesses will see in the medium term from this new regime. Proportionality, and this again goes back to the point that we made earlier on about the kinds of work, kinds of issues that we're going to tackle, really focusing on those that have the greatest impact upon consumers and businesses. So you will see us targeting that most egregious conduct where perhaps we've been very clear in the past, or others in the consumer landscape have been very clear. There's a sort of a direct negative impact on consumers and businesses. And we really want to make sure that the harm doesn't arise, and where it does, that consumers leave the situation whole again and in their prior state. So you will see us sort of prioritise where possible redress measures and things that can put consumers back to where they were. And that again goes back to trust and confidence, and making sure that where things do go wrong, that they are handled swiftly and effectively, because that again supports consumer trust and confidence in markets. And when we are considering using our stronger enforcement tools, and particularly if we're thinking about penalties, we will take into account the measures and that sort of proactive steps that businesses have taken to address issues. As always, we will take into account our prioritisation principles, which I'll come on to in a moment as well. Finally, process, which is where we have done, I think, the most significant amount of work so far, and you'll see this in our new guidance, which I think Andrew has included a link to in the chat, is an entire new document about the process that we will follow for direct enforcement, and that really unpacks in quite significant detail what you can expect from us throughout the process, each stage, what it's going to look like, what it will feel like, what we expect of you, what you can expect of us, where you have concerns, your sort of rights, whether that be a sort of procedural challenge or perhaps an oral hearing and representations. And again, you'll see us try to streamline cases and resolve them as quickly as possible. But it has always, and it will always be, our primary concern that we run a very robust, fully evidence-based process. And again, we'll need cooperation from all parties involved to help us there. And if at any point during the process you feel unsure about what's happening or what's going to happen when, you must tell us and let us know. One sort of final point that I sort of wanted to make on that as well is that, and perhaps we'll come on to this later as well, is that I really want to encourage you to contact us proactively where you see concerns in market, and that helps us, both with the process of thinking about which issues we should prioritise and where it's most proportionate for us to act. So if as a business you are feeling that you are at a disadvantage, that there's not a level playing field, that you are doing the right thing by your customers but somebody else is not, sort of strongly encourage you to let us know about that so that we can take that into consideration when we think about our prioritisation criteria. But as I hope that you've sort of gleaned from what I've said here, is these 4 Ps are commitments from us and things that you'll see us doing differently, but they really do rely on you being open and engaging with us in the process, and at times you may need to be very honest with us about how you feel, and we strongly encourage that. I'll move on to talk now a little bit more about the regime as a whole. We've talked a lot today so far about things that are changing, what is looking and feeling different, but some things are remaining very similar, and our commitment to working incredibly closely with our co-regulatory partners is staying exactly the same. So we are the only enforcer in the landscape with direct civil enforcement powers, but civil, criminal and other sort of self and co-regulatory functions remain in the landscape. And so we remain absolutely committed to working with our partners, whether that be through the Consumer Protection Partnership. We have concurrency groups, we have excellent bilateral engagement with other enforcers and consumer groups and trade bodies as well. So that will absolutely remain the same. And you will also see us still thinking about our prioritisation principles. So yes, the model has changed, but we will continue to think about where's there going to be the greatest impact and who is best placed to act. Sometimes that will be the CMA, sometimes that will be the role of a sector regulator or trading standards, and we'll continue to have those really kind of good constructive relationships to work that out, because we really, I think, do need to think about our action to support strong consumer protection alongside the action that all other enforcers are taking in the landscape. And we also maintain very strongly our international coordination. So we are members, and I will get some of the acronyms wrong, I'm sure, but ICEPEN, OECD, UNCTAD and others, where we will continue to promote kind of good practice outside the UK where it's for the benefit of UK consumers. We will continue to keep up to date with action that's taking place outside the UK. We know that many of the issues are common to a number of our international authority partners, and where there is parallel action, we are committed to ensuring that we stay as looped in and as coherent on that as we possibly can. So that is one thing that will not be changing, absolute commitment to working closely with partners. And on that, I think I'll hand over back to you, Sophie, to talk about some of the changes that have been brought in a bit more detail.
Thank you. Yes, just turning to the unfair commercial practices, I wanted to draw your attention to two materiality provisions, or two provisions that have changed in particular. So one, the transactional decision test for assessing unfairness has been streamlined because it removes the materially distort the economic behaviour limit of the test. And the second one was that we have removed, the Act removes the transactional decision test from the omission of material information where there's an invitation to purchase. Further, there is a power that the Secretary of State now has to add to the banned list. So as Emma was explaining, the banned list is essentially the list of commercial practices which are in all circumstances considered unfair. So there is no need to look at the impact on the transactional decision of the consumer. These are all set out in Schedule 20, and one of the new ones which has been added is Ban Practice 13, which is in relation to fake reviews. So I was going to spend a little bit more time talking about those. It is one banned practice, but it has multiple facets to it, and it covers conduct and practices on the entire review supply chain. So firstly, it bans submitting or commissioning fake reviews, which I think is probably the most understood, but it also bans concealed incentivized reviews. So it means that you can have an incentivized review, but then it mustn't be hidden or concealed, and that must be therefore prominently displayed. There is also a ban on offering services to traders to submit or commission fake concealed incentivized reviews, or to publish consumer reviews or consumer review information in a misleading way. And similarly, a ban on offering services to traders that facilitate either of these two things. I wanted to pause a little bit more on what the provisions mean for actual publishers, because there are two key provisions for anyone who's actually publishing reviews. One is ensuring that you do not publish in a misleading way. So publishing in a misleading way could include if you allowed a consumer review information to be determined or influenced by accepting a permission from a trader, for example, in order to give greater prominence to rankings. So that's one way and one thing for publishers to consider. And then the second is publishing reviews or review information without taking reasonable and proportionate steps as necessary to prevent and remove from publication fake, concealed, incentivized reviews or false and misleading consumer review information. So obviously what is reasonable and proportionate will very much depend on the circumstances at issue. But we did think quite carefully about what this provision might mean, and we wanted to provide further, hopefully helpful guidance to businesses in terms of unpacking this and thinking about what steps they might take to show that they have actually taken reasonable and proportionate steps. So I thought we've got on the slide a diagram that we've actually put in our guidance, and I thought it would be helpful to just take a little bit of time to talk you through the steps that we would expect businesses to have considered taking. So the first is essentially to have a policy. So to have a published policy. We think it's really important that businesses consider and set out their approach to incentivized reviews. Are they allowed on your website or are they prohibited? And for it to be clear to anyone publishing a review. The policies, you should ensure that they're readily available to users as well. So then the second step that we consider is critical is to conduct a reasonable proportionate assessment of the risks that consumers may encounter banned reviews or false or misleading information. And that risk assessment will very much determine what other steps you as a publisher would then take. So it's really about considering the risk of consumers encountering the fake reviews in terms of undertaking the assessment. I mean, it should very much be an evidence-led assessment, and you could use internal and external sources which are readily available to you in undertaking that assessment. So once the assessment has been undertaken, if there is a risk, then at a minimum, we consider that you should have processes and policies in place in relation to detection, investigation, and actions. So practically speaking, what does that mean? So I think it really means taking some proactive steps on detection. So that could include a combination of controls over review sources, checks by publishers, and third-party notification systems, though that's by no means a sort of set or limited list. Once you've detected banned reviews, or you've got a mechanism for detection of banned reviews, there's then an investigation that would then need to be conducted to determine whether or not reviews that you think might be fake are in fact fake or not, and we'd expect them to be proportionately conducted. And then, of course, actions. So that would very much be removing banned reviews, ensuring that any banned reviews don't impact on consumer review information. So that's any information that aggregates or uses reviews of any kind. So it's essentially making sure that the overall ratings don't include the banned reviews. And then it's really whatever measures you think are appropriate for sanctioning those who facilitate banned reviews, for example. And this must be effective at dissuading, but also reasonable and proportionate. And then we would obviously recommend that anybody who has been required to go through all of these steps conduct regular assessment on the effectiveness of the prevention and removal processes, and really whether there were not the risk when they conducted their risk assessment has changed over time, such that additional steps, such that you can assess whether or not additional steps are required. In considering what might be reasonable and proportionate, I mean, as I said, it will very much be driven by circumstances. So it could very much depend on your business model, the publisher's business model, the source of the consumer reviews or consumer review information, the publication medium's functionality, the type of content that's shown to consumers. So there'll be a number of different factors essentially that sort of play into the risk, and we sort of tried to set out in our guidance what they might be. So I'd basically I'd urge anybody who is in a situation of publishing reviews to take a look at that in more detail. And we've also published a business friendly explainer that goes alongside with that, which provides a sort of high level overview. So that was all I was going to say about fake reviews. I thought I'd also touch on the other section, which is new to the DMCC Act, which is section 230, in relation and deals with price transparency. As Emma had said, we had a lot of responses in relation to our consultation on the draft guidance in relation to this. So what we sought to publish in the final guidance was very much an overview of section 230 to assist businesses, and then we are reflecting further on the feedback that we have received, and will be reconsulting in relation to section 30 in the coming months. But for today, I thought it was worth pausing and just showing you the sort of overview and the considerations the businesses should take into account. So it's really whether or not consumers will necessarily incur payment of a charge being any fee, tax charge or other payment. If no, then this would be then outside the scope of the requirements of section 230, although you would need to comply with other provisions of the Act if it was material information. But if yes, the charge is then mandatory, and you then need to consider whether the nature of the product means that the charge can or cannot be reasonably calculated in advance. If it can be reasonably calculated in advance, then it must be included in the total price in the invitation to purchase. And if it can't, then you must give sufficient information for the consumer to be able to calculate the total price that they will pay. So that's an overview of the price transparency provisions in section 230. And I was now going to hand over to Emma to talk us through what comes next.
Lovely, thank you, Sophie. So in terms of what you can expect over the next 12 months? Well, first of all, as Sophie's just mentioned, we will be consulting further on Section 230. As she's explained, there is a clear section in our guidance at the moment that sets out really the core of drip pricing harm. That Section 230 was brought in. Our view is that that is very clear, and drip pricing has been prohibited under the law already. Section 230 clarifies that, but our position is that we can take enforcement action if we need to, in relation to conduct that doesn't comply with the action set out in the guidance. But as Sophie's mentioned, we did receive a lot of feedback from businesses that there were areas that were more complex, where they needed more help. So, for example, things like fixed term monthly contracts. And I think one of the questions which we received around how you work through taxes that are, it's unclear what tax is actually going to be payable, as well as a number of other issues. And so those are issues that we will be thinking about further, and we will be engaging with businesses, with consumer groups, with advisors over the next months, both before we go out for the further consultation and then during the consultation. So that you can expect that to happen in the spring, and then the consultation process will run, and we will aim to publish final guidance that covers all of those points on drip pricing in the autumn. The second thing that you can expect to see from us over the next 12 months is a lot of engagement. So more of this type of engagement through webinars, as well as attending roundtables with businesses, speaking at events that are hosted by advisors, by consumer groups, working with many of our partners in the enforcement landscape, including trading standards, including our partners in government, including other sector regulators. So to ensure that we are hearing the feedback from the early days of the regime, and to ensure that we understand where it is that we need to deploy our resource to help businesses comply. We're also hoping for increased engagement from businesses, as Hayley mentioned, to tell us about where there are problems in your markets that we should look at in greater detail. And the QR code on this slide will take you to our reporting page. This is one to use if you're a business. If you're a consumer, we would still direct consumers to use the Citizens Advice page, because that is the richest source of data for consumer engagement, and also where consumers can get direct advice from people who are trained to assist them with their consumer challenges. But for businesses who want to tell us where there are problems in their markets, where they are being disadvantaged by those that are not complying with the law, then they can report to us via this webpage with the QR code there. We would say, if you do want to give us this information, it is most helpful to us if you can provide detailed evidence and explanations for why you think there is a breach of the law. Businesses who are active in the market will understand it the best, and so providing that context and detail for us will help us quickly to understand whether it's an area where we should act, and to apply the prioritisation framework that we think about when we're deciding whether to act. Last but by no means least, we are focused carefully on developing our early cases and thinking about where and how we should take action over the next 12 months. We've been monitoring the behaviour of a number of businesses, really across sectors throughout the economy, and different types of behaviour. It's been great to see that as of the start of April, a number of businesses have changed practices that we were looking at, which is a great outcome for both those businesses and for consumers generally. And we would like to see more of that, these proactive changes that businesses are putting in place to ensure that they are complying. For those businesses that haven't yet changed their practices that we're monitoring, we'll continue to look at those. We will continue to think about whether or not those are cases where we should use our direct enforcement powers for the first time, or whether it is more appropriate to use those to provide early guidance, to use, for example, our advisory letter tool or our warning letter tool. So plenty of work going on to think about how and where we should deploy our powers.